For decades, minority groups living in the United States have been given preferential treatment or special consideration when applying to college. But in one U.S. state, voters decided that the so-called affirmative action policy should end. The ensuing argument escalated and went all the way to the nation's top court. Steve Handelsman reports for CCTV from Washington.
In a referendum in 2006, 58% of Michigan voters approved amending the state constitution to ban any consideration of race in public college admissions and public employment. At the Supreme Court, the six-justice majority upheld that process. Justice Anthony Kennedy writing, "This case is not about how the debate about racial preferences should be resolved. It's about who may resolve it." The court did not rule on the constitutionality of affirmative action, but opponents are still celebrating.
Well, we live in a time with a black president, a black attorney general, when to make the kind of claims that people are being discriminated against and being prevented from entering into positions in a university or a job at a hospital or a public employment project simply no longer makes sense.
The NAACP says affirmative action is still needed.
Segregation and racial inequality exists throughout this country. In housing, we see it in employment, we see it in schools. And so that is something that must be addressed.
Justice Sonia Sotomayor agreed, saying judges ought not sit back and wish away racial inequality. And she said of the Michigan referendum, democratically approved legislation can still oppress minority groups. 8 states now ban consideration of race in admissions and hiring, and more states are now expected to ban it. At the University of Michigan, since the ban took effect, black enrollment and Latino enrollment have dropped. From Washington, I'm Steve Handelsman for CCTV.